Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we are going to break down all of the judicial opinions that were released in the Dobbs versus Jackson case by the U.S. Supreme Court overruling Roe v. Wade and Planned Parenthood versus Casey. Now, these opinions constitute over 260 pages. So obviously I'm not going to be able to go through every single page of these opinions, but kind of just want to give you a breakdown of how each of the judges who wrote an opinion took on their position, what their reasoning was, and see if we can kind of anticipate what impact this may have on other rulings, such as marriage in the LGBTQ community, contraceptives, and other things that involve so-called privacy rights. So want to talk about this case and what impact it may have for future cases. So if you found this helpful, please subscribe to the channel, like the video, hit the notification bell. And with that, let's jump right in. So I've already done a previous video breaking down the majority opinion, which was written by Justice Alito, who essentially argued that the substantive due process clause of the 14th Amendment, incorporating the idea of some privacy rights to the states, was not properly reasoned and decided in Roe v. Wade and in Planned Parenthood versus Casey. Essentially, the substantive due process clause says that it protects rights that are deeply rooted in our nation's history and necessary for the orderly continuance of a community or government and people. They're necessary to ordered government and ordered society. And so the court back in 1973 in Roe v. Wade had determined that the right to an abortion was one that was deeply rooted in our nation's history and was necessary to an ordered society. And while Roe v. Wade in its reasoning wasn't affirmed in Planned Parenthood versus Casey in the 90s, it did not remove the woman's right to have an abortion, but instead created a undue burden test. And Justice Alito essentially goes through the two opinions in Roe v. Wade and Planned Parenthood versus Casey and decimates them and says why the reasoning was not accurate and why it is not a good case for precedential value. And he actually lists a several-page appendix at the end of the opinion where he puts all of the different laws that criminalized abortion in the years leading up to Roe v. Wade, and how the idea of a fundamental right to abortion was actually a relatively new concept in comparison to the opposite view, which was deeply rooted in his opinion in our nation's history. So that was the basis of the majority opinion. I'm not going to spend any more time on that because, like I said, I've already done a video on that. You can go back and check out that video. What I want to do the rest of this video is go through each of the other judges' opinions. So the first concurring opinion is by Justice Thomas. Now, a concurring opinion is one that says, I agree with the outcome of the majority opinion. I agree with the outcome of how the case is going to go, but I may have differences of opinion in the reasoning or maybe some difference in how this should play out in future cases. Justice Thomas agrees with the outcome of Dobbs versus Jackson, but he says that while the court gave good reasons about why abortion does not fit within substantive due process, Justice Thomas would not use substantive due process as a test. He essentially says that substantive due process is an oxymoron. It's something that doesn't make sense when you put it together. Due process is procedural in his mind. Substance is substantive. It is something that determines rights. And due process does not give someone rights. Due process protects rights that already are in existence. And so in his view, abortion would not be able to be a right that's protected by due process, because that's not the role of what due process is. Due process doesn't give a right to abortion. Due process protects rights that are already have. And unless they can show that abortion was already a right that existed, and that is needed to be protected by due process, Justice Thomas says that wouldn't qualify. So the substantive due process rule itself, he would do away with. Now, with that thing in mind, he mentions cases like Griswold and Obergefell, which deal with contraceptives and deal with gay marriage. And if we follow his reasoning, then some of the more liberal justices' opinion that we'll be looking at earlier may come to fruition, because in his mind there would be no federal right to contraceptions, there would be no federal protective right to gay marriage under the substantive due process. Now, he would say that perhaps some of these rights should be invoked in the privileges and immunities clause, but that would be a different test than what any of these opinions had done, and plus those are not issues that have come up before the court because they have been somehow fit into the substantive due process issue. But if Justice Thomas's reasoning were to be accepted, and there would be no substantive due process incorporation of rights into the state, then of this privacy right, then there would be some concern that Griswold could be overturned, that Obergefell could be overturned, and so that is something that would be legitimate. But under the majority opinion, as it completely is reasoned, they note the distinctions between the issues relating to Griswold and the issues relating to Obergefell, and they note that this opinion has no bearing on the right to marry, which is a long-standing, deeply rooted issue. Now, is the right to gay marriage specifically, or LGBTQ marriage, deeply rooted in our nation's history? Well, they don't really deal with that. They just simply say that marriage is something that's deeply rooted, and therefore this opinion has no bearing currently on those other precedents. So that's the distinction between Thomas's opinion and the majority opinion. In Justice Kavanaugh's concurring opinion, he also agrees with the majority opinion, but he says that this is not the time to eliminate substantive due process rights. And the takeaway from his concurring opinion, whereas Justice Thomas would eliminate the substantive due process rights in this case, Justice Kavanaugh says that this is not a case that presents the ability for this court to dispense with substantive due process rights. However, he says that in the future, if a case comes up that presents such an opportunity, then this court should jump at the chance and eliminate it. He says, in future cases, we should, quote, follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with that textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest opportunity. Now, that's an interesting thing to do, because he's commenting on what should be done in future cases. The courts usually don't do that. They generally leave their opinion based on what this case does, but they don't say how courts should rule in the future. And in fact, in confirmation hearings, often when the senators ask the potential candidates for the Supreme Court how they would decide on a matter, they say, well, we can't really comment on how we would decide in future cases. But Kavanaugh is essentially, sending up a flag here to say, hey, look, at some point in the future, there's going to be a case that's going to present an opportunity to eliminate substantive due process. And when it does, we should jump on it. So he agrees to some extent with Thomas and what should happen in the future, but he does not agree with Thomas that it presents itself in this case. So that is the substance of Justice Kavanaugh's concurring opinion. Chief Justice John Roberts also concurs with the majority opinion, although he would do it differently. His reasoning is one that is a long-standing judicial principle called judicial restraint. In other words, the Supreme Court should only rule on what is absolutely necessary for the outcome of the question that is before the court. Now, the specific question in Dobbs was how to determine viability of a fetus based on a certain number of days, the statutory definition of that. And Roberts would agree with the outcome of this case because he says that the viability tests under Roe v. Wade and under Casey versus Planned Parenthood versus Casey are not well reasoned and should be overturned. But he would not full scale overturn the right to an abortion completely, because he says that's not what this statute is asking. That's not what the question is that this statute presents to the Supreme Court. So he would say that, in regard to this case, he essentially would limit it to the facts of this case, and eliminate the viability arguments, but not say full scale that there is no right to abortion. So he essentially would argue that maybe there are there is a fundamental right to have an abortion, but it would not be based on the tests that were presented in Roe v. Wade or Planned Parenthood versus Casey. Now, if his reasoning were accepted, then there would be some limitation, obviously, to this right to an abortion, but it wouldn't be exactly clear what that test would be. And he says he agrees with the court that the viability lines established by Roe and Casey should be discarded under a straightforward stare decisis analysis. That line never made any sense, and so he says that right should extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. But the court will no longer decide the fundamental question of whether abortion must be allowed throughout 6 weeks, 12 weeks, 15 weeks. Instead, they basically just say there is no right to abortion at any point and leaves it to the state. So Roberts would not agree with that. Under Roberts' opinion, states that banned abortion outright would be in conflict with his opinion of how it should go. It says, under the narrower approach proposed here in his concurring opinion, state laws outlawing abortion altogether would still violate binding precedent. And to the extent states have laws that set the cutoff date earlier than 15 weeks, any litigation over that time frame would proceed free of the distorting effect that the viability rule has had on our constitutional debate. So essentially he's making this 15-week determination kind of like a bright line test almost, and that would still give women a right to an abortion. He chides the majority opinion as well as the dissent for saying that there is no doubt in one aspect or the other. He chides the remainder of the majority for being so staunchly against a woman's right to abortion, and he chides the dissenters for being so pro-abortion that they can't see any other way. And essentially Roberts is trying to play the role of the third way, that says, well, we got to leave some room for women to have a right to choose, but then we also need to make sure that we're not falling prey to bad reasoning and the viability test. So he's trying to create this third way, but ultimately he decides to join in with the majority outcome, but wants to be able to hold out for whatever reason. I don't know if he's trying to pacify both sides, but unfortunately most of the time when people try to pacify both sides, they make enemies of both. So we'll see how that plays out in the court of public opinion. The dissenting opinion is written by Justice Breyer and is joined in with Justices Kagan and Sotomayor. And to no one's surprise, they would affirm Roe v. Wade and Planned Parenthood versus Casey. And they argue at the majority for overruling 49 years of precedent since Roe v. Wade. And they start to say that all of that is opening Pandora's box for all of the other liberal rights that have been created over the last 50 years or so, like gay marriage, contraceptives, and they're basically just trying to scare everybody into being outraged with the majority opinion. They don't really give strong legal analysis. They basically just argue on the basis of stare decisis. They can't make a good case about why Roe v. Wade or Planned Parenthood are well-reasoned cases. They just say they are the law of the land, so therefore we should follow it. They also don't really spend a lot of time on the companion case of Roe v. Wade, which was Jane v. Doe. And in that case, whereas the dissenters are saying, well, the undue burden test allowed the states to have some ability to limit abortion, but they ignored Jane v. Doe, which says that abortion can be granted essentially for any reason that the mother wants, because that case said that it's not just the life or physical health of the mother, but also included psychological, mental health, financial, economic problems. So there was really no way for a state to regulate at any point in either Roe v. Wade or Planned Parenthood versus Casey. There was no way for a state to be able to overcome, because Jane v. Doe in both of those cases continued to be the law of the land, which gave mothers the right to terminate an unborn child or fetus, whichever side of the aisle you want to argue from. So they ignore that, and so it's basically just a yelling match. If you read the dissenting opinion, it's not well thought out. It's just an angry tirade. In fact, one of the lines in there, it says "anyway," and then it goes on to making the argument. I've never seen that in an opinion, but you can tell that when he was writing, he was not very happy with the outcome. So it is what it is. But so what does this mean going forward? Is it likely that there's going to be contraceptive bans and bans on gay marriage and things of that nature? Probably not. This opinion, it's pretty well set in stone with the majority, even the conservative majority, that those rights are not going to be able to be violated, and it's going to be a tough sell to get Roberts on board to overturn any of those things, clearly. And then, obviously Justice Thomas and, Justice Kavanaugh would eliminate substantive due process, but there's no indication from Barrett or Alito that would, or Gorsuch, that would be the case. So it's hard to say that's likely to come to fruition. So, I wouldn't stress out about that. It's just a lot of fear tactics. What do I think about this opinion? I mean, honestly, I think that it's a pretty well-written majority opinion. When I was in law school, I had problems with Roe v. Wade and Planned Parenthood versus Casey, not just because I'm a Christian and I think that unborn children are children and that they're made in the image of God. That's just a personal belief of mine, and that I get from my study of the Bible. People who are not Christians may not agree with that, and that's okay. But my problem as a law student was with the reasoning of the case. It didn't make any sense. This whole idea of viability and why does a court get to decide that? That's not the court's function to determine what viability is. That's the job of legislators, those who you elect. It's their job to set those parameters. And the elected officials have been trying to hide behind these cases, and now we're going to see who is really for what. And that's what you want to be able to see out of your government officials. You don't want them to be able to hide behind the robes. When you elect people in the office, you want to be able to see what they truly believe. And you've had people on the Democrat side who say, well, I personally am against abortion. I'd love to see it be overturned, but the judges have decided, and that just is what it is. Well, now we're going to see if they really believe that, or if that was just all talk. And it's going to be the same with some of those on the Republican side who say, well, I'm very, very pro-life and I'm against abortion. But then when their constituents come in, and those who have either committed abortions or had families that committed abortions, and they start taking money away or giving money to or whatever, it'll be interesting to see what the true beliefs of our politicians are, because now they have to decide. They're going to have to decide in the states. Our governors and our assemblies and our legislatures and all that are going to have to decide what we want the states to be able to do. So this case does not end abortion. It just turns it over to the state elected officials to decide what they're going to do with that. So now the people truly get to be involved, because if the overwhelming majority of society believes that abortion is something that should happen, then they elect officials that will allow that. And if they don't believe that, then the people will elect people that don't believe that there should be abortion. So it doesn't necessarily end abortion today. It just simply He sends it to the states and to the people to decide. It's essentially reserved under the 10th Amendment, reservation amendment. All rights that are not explicitly given to the federal government are reserved to the states. And of course, when it says the states, it also references localities as well. So hope you found this helpful. Put in the comments what you think about the opinions. What do you think about Justice Alito's opinion, Justice Thomas's, Kavanaugh's, Roberts, and Breyer's? What do you think is the right way to go about this, and what do you expect to be the outcome in politics regarding this issue of abortion? Please let me know in the comments. Hope you found this video helpful. Again, I'm Drew Page. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.